(2014-183) State of Arkansas versus Adam Webb. This matter is for arraignment on charges of forgery in the second degree, Class C felony.
Your Honor, on behalf of Mr. Well, we've been in a plea of not guilty, waive formal arraignment. Your Honor, as the court can see, this gentleman is incarcerated in ADC. Mr. Kincaid and I will talk. We will do our best to get this resolved today, and that's the instructions I have from Mr. Webb also.
The court will call 2013-267 State of Arkansas versus Cody Bowers. All right, Mr. Bowers, you're appearing here today for purposes of changing your plea on the charges, is that correct?
Yes, sir.
And this plea change comes about based on an agreement that's been worked out for you by your attorney, Mr. Russo, is that correct?
Yes, sir.
And have you discussed the terms of the agreement and the punishment you're to receive with
Yes,
Mr.
sir.
Russo? Have you?
Yes.
All right. And do you feel you thoroughly understand what the terms of the agreement are?
Yes, sir.
And are you satisfied with the advice and the representation Mr. Russo has provided you?
Yes, sir.
On the charges of delivery of a Schedule II controlled substance, a Class C felony, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to this agreement, and the agreement is actually set out in writing in this document I'm holding up called a plea statement. Have you read through this plea statement?
Yes, sir.
And is that your signature that appears on it in two different places?
Yes, sir.
So you've read through it and signed it.
Yes, sir.
Do you feel you understand what's set out in the plea statement?
Yes.
You do.
Yes.
All right. You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender when you enter a plea of guilty?
Yes, sir.
In pleading guilty, you give up the right to jury trial. You give up the right to be represented by an attorney and have the assistance of that attorney throughout the trial process. You're giving up the right to confront the witnesses that would appear and testify against you at trial, and you're also giving up the right to appeal. Do you understand these rights?
Yes, sir.
And understanding the rights you're giving up, are you still willing to enter this plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
And in entering this plea of guilty, has anybody in any form or fashion forced you into entering this plea?
No, sir.
As you plead guilty here today, do you acknowledge the truth of the accusations against you?
Yes, sir.
Do you acknowledge that on or about the first day of August of 2013 here in Baxter County, you participated in the sale of five I'm not familiar with this particular medication, but some 5 hydrochloride pills
Yes, sir.
listed on Schedule 2 of the Arkansas Controlled Substance Act. Based on those statements, then, the court will find the defendant has freely and voluntarily entered his plea of guilty, done so after consulting with an attorney, and has acknowledged the facts that constitute the crime. On that basis, the court will formally accept the plea of guilty, but pursuant to the agreement in this case and pursuant to Act 346 of 1975 as it's currently amended, the court will withhold formal adjudication of guilt on this time and place the defendant on 6 years of supervised probation, subject to the standard terms and conditions of probation of this court. The defendant is ordered to pay court costs in the amount of $200, a fine of $1,000, drug crime assessment of $125, and a statutory booking administration fee of $20. All of those amounts will be due and payable as a term and condition of his probation, payable at a minimum rate of $100 per month to begin within 30 days of this date. The court is also ordering, as a condition of his probation, that the defendant will continue in the treatment program that he's currently and has previously and now currently participating in, and is subject to revocation if he quits the treatment program prior to being released by the treatment counselors. On that basis, the court, at this time, the court will direct that the defendant will meet with the probation officer to get set up on probation. The court has signed the written terms and conditions of probation, making them an order of this court. The court also points out that for the record, that the defendant has signed those acknowledging that he has read, understands, and will comply with the terms and conditions of probation. All right. Meet with the probation officer, get set up on probation. You may be excused.